Sorry about that. We have a little problem with our audio in the Roy Oliver verdict, but luckily we have some expertise here. Michael, thank you so much for joining us today. So you're a former prosecutor, right?
Former prosecutor.
Former prosecutor, now criminal defense attorney.
That's correct.
All right. So let's talk about the Roy Oliver verdict, because this trial was very, very short. I mean, we didn't really see too much of the meat and potatoes of the trial, and now we're going to be moving into the sentencing phase. But what do you make of this? I mean, guilty of murder. I believe Roy Oliver, in his defense, said that he feared for his life.
It was an interesting trial because, number one, is it's very unique for a criminal defense attorney to have a client he can put on the stand with ultimate confidence. When you have a police officer, you basically have someone who's trained to testify. He's testified before. It's not like a usual defendant who's never testified or doesn't have that experience. Oliver took the stand. I think his problem was that the person he was supposedly protecting, the fellow officer, testified that he never felt in danger, and I thought that was where the biggest hurdle they had. And no matter what kind of job he did on the stand, he had someone who he claimed he thought he was protecting saying they never felt he was in danger, and I think that was really what tilted everything in the favor of the state. Right,
because as we know, the defense had said that he was actually in fear for his partner's life, and again, a viable defense would be if there's fear of grave bodily injury or death to you or somebody else. So that might have worked, but you felt that his testimony didn't quite pass muster.
Well, it didn't carry the day. It was too inconsistent with what everybody. Listen, whenever a defendant takes a stand, everybody knows he has a vested interest. This guy's literally fighting for his life. But he said the car was backing up. Other people testified the car was driving away. He said he heard shots from the car. Witnesses with not so much of a vested interest said the opposite. I think it was a very difficult case for the defense, and it just seemed that all the corroborated, credible evidence really went into the prosecution's favor. And the jury, I obviously believe the same thing.
Right. The jury ultimately made that decision, a verdict yesterday in the Roy Oliver case, guilty. Now, we heard some victim impact statements last night. Listen to and I mean, this is really just heart-wrenching. This is the statement of Jordan Edwards' father. Take a look. That is the victim impact statement of Ndele Edwards. That's Jordan Edwards' father. Just absolutely heart-wrenching to hear about the terrible loss of his son. Michael, so let's talk a little bit about victim impact statements just generally, because that was very moving. We heard prior to Ndele Edwards' statement, we heard from teachers who just talked, that thought the world of Jordan Edwards, and now he's lost his life in this seemingly just unnecessary way. What do you think the jury makes of these statements?
Well, I'm sure there's some parents on the jury, and what rung the deepest to me and the loudest was that's every father's nightmare, mother's nightmare, that when your child leaves your home and you expect to see him come back and he doesn't come back. I mean, that's got to move every one of those jurors, because it's moving every parent across the country who's listening to this.
Absolutely. And he's guilty, so this is all having to do with the sentencing, which is aggravating and mitigating factors, right? That's what they're going to weigh. These statements mean something, right?
These statements will weigh very, very heavy in the jury's mind and the judges.
Absolutely. So that's what we're going to see. And we will be watching more of the victim impact statements that we heard in the Edwards case. Again, we've heard from several teachers before, his father, everyone just talking about how wonderful Jordan Edwards was. And it's just such a horrible shame that he lost his life. We have to go to a break, but please stick with us. We have more on Law and Crime today. That was Rosalinda Medina. This is the penalty phase of the Roy Oliver trial. He's facing 5 to 99 years for the murder of Jordan Edwards. Michael Koribanics, criminal defense attorney. All right, so now we see, in addition to some of those statements that had to do with Jordan Edwards and what a great kid he was, and how tragic this loss is, now we're seeing some people painting Roy Oliver in a very negative light as someone who's not a stranger to police brutality.
It's almost, as she was speaking, I thought of the father beforehand, and you're saying 5 to 99 years, and it just seems like that register is going up with each witness that's being called. This is almost jaw-dropping when you're looking for a police officer for assistance and he comes and you wind up in this situation. It's just totally mishandled and really is not protecting the public. This is very bad for Oliver.
Absolutely. So this serves as what we call the aggravating factors, right? And the jury gets to consider all of this?
They get to consider this. They get a whole picture of what Oliver's like, and it sort of makes it look even more heinous that this death occurred at his hands, and there were all these warning signs prior. I'm sure they got this person through internal affairs or some way to find that person, and that's how they. So yeah, he probably has a record of past wrongdoing.
Well, that will certainly make an impact with the jury, but only time will tell where the sentencing lies. We will keep on this case. We do have to go to a break, but stick with us. All right, so that was Darby Hutchinson, Tennessee Bureau of Investigation. We heard right at the end of her testimony, the conclusion was that this fire was intentionally set. Let's talk to Mike Koribanics about this, criminal defense attorney. This is kind of a tough case here, and I think we were all a little shocked when we heard the defense say at the beginning of the case, you are going to hear from our client in testimony. I mean, you take a risk in any case putting a defendant on the stand, but in this one, we know about a previous conviction, which maybe we'll have an opportunity to talk about, but is that a good idea?
Well, in my opinion, there's nothing more sacred to a criminal defense attorney than the fact that your client has a right not to testify and that can't be held against them. And the state has all the burdens of proving the case beyond a reasonable doubt. So the credibility of the attorney is important. When you open to that jury and you say you make the promise that your client's going to testify, that's going to be in the back of their head through everybody who testifies during the trial, as opposed to them focusing on who's testifying and what they're saying to prove their case. They're going to start wondering, oh, wow, he said they're going to testify. What's she going to say about this?
Oh, yeah.
So you've built up anticipation where I don't think it's needed, but it's very difficult to second guess another attorney because I don't know what he has or what he's thinking.
You're right about that. And hey, listen, the jury is definitely going to be thinking about that the whole way through. And if you say your client's going to testify in your opening, you better deliver. Anyway, live in the courtroom now, the first witness is on the stand. So we're going to go live to the Kilgore court. Take a look. That's Paige Durham from the Sheriff's Department talking about what was confiscated from the defendant when she was brought to jail. Now, you saw a lot of regular run-of-the-mill items, and then you also saw a knife. We also know that there were a dozen handguns in her vehicle. So, Michael Koribanics, let's talk about this. I mean, the dozen handguns in the vehicle, that's not looking too good for her, right?
No, it's almost unbelievable that, you know, someone who is accused of doing such a heinous crime and doesn't get arrested on the scene. It's not like she was pulling away and they pulled her over and she has the guns on the car. Now, granted, all they prove now is she's in possession of stolen merchandise, being the handguns, but she was on supervised release for a federal charge, and she's driving around in a car with over a dozen handguns that are claimed to be stolen from a pawn shop.
Now, Michael, I really wanted to get into that because she is on federal release, and originally she was. There's a separate warrant for violating the terms of her release, which obviously says you can't have firearms in your car. That was from another botched robbery, except no violence in the last conviction. She went in to rob a bank, and the bank teller said, "Well, we don't have that kind of money. Fill out a form." And in that time, she was confiscated. So you're putting this person on the stand?
Well, that's really where, you know, like I say, you never know what the defense attorney has in his file or how his client reacts. But, I mean, here's a person who went to rob a bank for $1 million, accepted the fact they'd only give her $500,000 in a check, and then filled out a form. I mean, seems like the prosecution's going to have a pretty easy time leading her where they want to go on their cross-examination should she take the stand.
Well, that's it. And the defense has promised her on the stand, and that's a lot of fodder for impeachment, I would say. So this should be a really interesting case. We have to go to a break, but we will be back live testimony in the Kilgore courtroom when we return. Stay with us. Okay, we're in the Angela Kilgore courtroom. She's accused of murdering pawn shop owner who was 72 years old in what was a botched robbery. So, Michael, let's talk a little bit about this case. There's a lot came out, and we saw in testimony yesterday. We heard from a witness that said she was at the pawn shop shortly before the murder. The victim was there. The last transaction in this receipt book at the pawn shop was the defendant, the other person said the defendant was there. So they've got that time proximity. Where do you think the defense is going to go? I mean, we saw the defense in opening saying their client's not guilty and the victim was fine when she left the pawn shop. Does this seem a little bit like a tough road?
It's a tough road to hoe, but the Constitution guarantees us that even through openings up until the jury makes a decision, your client's presumed innocent, and the state has the burden. The thing that threw me a little bit in the opening of the defense was the promise, as we spoke about earlier.
Right.
And it's something you can't really speak enough about, is that the promise that the defense made that they're going to put their client on the stand.
Well, yeah, and I mean, look, I think right now we anticipate in the prosecution's openings, they talked about a folding knife, which has the victim's blood DNA on it. We know she had these guns in the car, which, again, okay, they're in the car. They're not in the pawn shop with her. But it seems like there's some combination of forensic and circumstantial evidence that is going to be a bit of a hill, a mountain maybe, for the defense. Do you think there was ever an opportunity to talk about a plea deal here in this type of case?
Well, I would hope there was an opportunity. I mean, lawyers can only do so much when they're defending their clients. Their client has the ultimate decision. The problem, even before you get to the forensic evidence and evidence of the case, is when you make a promise that she's going to testify, is we know the first thing the prosecution's going to do is confront her with her prior convictions.
Right.
Because under the rules of evidence, you're allowed to do that to impeach her credibility. So they're going to know, this jury, that this is not the first barbecue she's attended.
Right, and let's talk about that, because one of the previous convictions, actually she has two previous convictions, one from 1990, one from 2004. Those are both robberies.
Right.
Or botched robberies that didn't quite come to fruition in 2004. In 1990, felony conviction for aggravated robbery. So, I mean, the jury's going to hear this. They're
going to hear it unless, of course, the judge says they're too remote in time and that they're too far away from this incident. However, I don't really know when she was done with her sentencing, serving it. So when the time runs in New Jersey, it's 10 years, and then with that, the conviction could be used. Then you have to come up with some proofs. I don't know what it'd be here, but the problem is you put your client on the stand and she says something like, I've never done anything wrong. Now you've opened the door and the prosecution's going to have a field day.
Yeah, and are they going to know she was on federal release to begin with? I mean, that's the thing. She's on this program where she's being watched. She has 12 guns in her car. Seems like this is going to be a pretty tough case for the defense. But hey, only time will tell. Innocent until proven guilty. We do have to go to a break, but then we will be back live in the Tennessee courtroom. Also keeping an eye on Oliver. Stay with us. We've been keeping an eye on the Oliver courtroom, where we can see there's some activity that looks like the jury is coming in shortly. This is the sentencing phase of the hearing. The jury reached a guilty verdict of Texas police officer Roy Oliver, finding him guilty of murder for the fatal shooting of teenager Jordan Edwards in April of 2017. Michael, let's talk a little bit about this case, because I think, look, we're going to hear maybe some overlapping facts in the penalty phase of the trial as in the guilt phase. But I think one of the most interesting parts of this case was, all right, you have Oliver on the stand testifying that he felt his partner's life was in danger. But then you have Officer Gross, the partner, with a totally different story, saying he was not in fear for his life. Do you think that was the linchpin with respect to the guilty verdict?
Well, I think it has to weigh heavily, because I think it sends a message to the jury. You hear a lot about the blue wall of silence, how police officers cover for one another, things of that nature. That's like the perception that's out there. This trial proved that to be false. Here's an officer who you would think would feel, if he was trying to cover for him, at least indebted to him for the protection out on the street. But obviously, they saw no room to even gild the lily a little bit here. he was in total contradiction as to what Oliver testified to. And this was the guy who really we'd think would say, the guy tried to help me, but obviously that wasn't what happened. And that's what I think the jury is really, I agree with you. I think that's what the jury weighed heavily with.
That was definitely a big part of the decision-making with the guilty verdict. Now we're in the penalty phase of the trial. Oliver is facing 5 to 99 years. So we're hearing victim impact statements and other testimony focusing on aggregating and mitigating factors. Let's take a look. So this is the defense first witness of the penalty phase of the hearing in the Roy Oliver case. And this young lady looks like a lovely young lady, you know, is presenting well, but we're all scratching our heads over here at Law and Crime, wondering why this is the first witness out the gate in support of Roy Oliver. Michael, let's talk about this, because I'm not sure that the fact that he's involved in her school and community, which is not the same school as Jordan Edwards, and taught these kids respect, really has any relevancy here, or is really going to sit well with the jury.
I feel bad for this young lady, because I think they put her in a bad position. She's, I think, testifying honestly to what she observed. The problem is Roy Oliver doesn't have any input into the community of that victim who he shot and killed,
right,
as a jury has found. And we have someone coming from a totally different community who really doesn't know much about this case, I assume, because nobody's asking her. And I just don't think this will play well for the jury, because I think they're going to read into this and wonder why she's on the stand, because what does this have to do with Roy Oliver in comparison to all the other things he's done, other than he likes to go to football games?
Right, yeah, so he's active in the community, he's helping kids out, he's trying to teach them respect. But we heard some witnesses for the prosecution talked about what he's like on the job.
Right, and he's not active in Jordan's community. And I think that really shows more of a negative inference to him than anything else. I think this witness would have been better not being called.
Yeah, and it may
and not a
be,
reflection on her.
No, she's lovely, absolutely, presenting well, young girl, doing very well, speaking on the stand, but certainly not who you'd think would be your primary witness that you're going to put out the gate to defend you against a potential 99-year conviction. So,
not your best first punch.
Yeah, interesting choice. I guess we will see where they go from here. Maybe they're saving the best for last. Not sure. Again, we're a little shocked over here. We're wondering about the relevance. We do have to go to a break, but we will be back live into the courtroom after for more witnesses in the penalty phase of this trial. Okay, well, we're watching the sentencing phase of the Oliver trial, and another interesting choice by the defense for a witness. So this is an acquaintance who lived in an apartment complex with Roy Oliver, talking about that, you know, he's a good guy, he was nice to the children. I'm still scratching my head. What do you think, Mike? I mean, I'm thinking that the defense would have been better off putting people on that saw him in his work capacity, because that's really what we're talking about here.
I couldn't agree more with you on that. I don't understand these two witnesses at all. They're people who, I mean, this isn't even a family member. It's somebody who's a landlord, it appears. And she's speaking about how he walked around the apartment complex and how much he cared for his baby. Unfortunately, he's accused of killing someone else's baby.
Yeah, convicted. Convicted of.
Convicted, right. You're right. And it just, to me, this is not helping their cause, because I'm sure that jury who convicted him is saying, yeah, what about Jordan's family?
Right, and I had a moment, and I'm sure that we get what she means. She's a lovely woman. I'm sure she didn't mean it this way, but she said, I couldn't believe what happened to Roy. And to me, I recoiled, because I'm thinking, wow, this jury just found him guilty of murder.
You're absolutely right. And the fact is, I would think you'd want witnesses on his behalf who work with him, who know him in the environment of which he's accused, of which he's convicted of having committed this act. You'd want people to say that this was an aberrant act.
Right, that this is an anomaly, right?
Right.
That he's a great police officer, always by the book. This is outside of his character. these witnesses don't really seem to be speaking to that. It'll be interesting to see who else they have. We do have to go to a break, but when we come back, more in the Roy courtroom. Live in the court in Oliver, and we just heard from a witness, Billy Gorwood, who's really an acquaintance of the defendant. During the break, we missed some great cross-examination in this case. The defense attorney asking, do you think that Jordan was shown mercy on that night? Asking the witness whether or not she knew about his past of about Oliver's past of some violent behavior being ordered to anger management. Michael, we saw that go down. You and I were sitting here like minds blown. She didn't really know anything about him, truth be told.
That's the danger of putting on these kind of witnesses who really just come in to really give you fluff. Because now the jury's last words they heard while they're deciding what to sentence him to was all his prior bad acts that this witness came in and had no idea about or said, I just don't believe it. And I just don't believe it is not going to help a convicted murderer in front of a jury who's deciding his fate.
Absolutely. That just doesn't sound right to me. Well, that's really not too compelling. One of the final questions, do you think that shooting into a car is dangerous, that people could be killed? And, well, yeah. But she didn't know anything about him in his official capacity. The defense attorney could have almost just said that. Have you ever seen him in action? No? Okay. Well, then you don't really know what he's like when he's on the job.
That's the danger. Sometimes silence is golden,
right.
And just putting on witnesses for the sake of putting on witnesses could put you further back in your quest to do the best for your client. And I think we're seeing that here. I think people are not getting up the hill or losing footing, and this is turning into a disaster.
Yeah. Well, one thing, Michael, you brought up a good point. These witnesses might work for somebody who, killed somebody in a bar fight. It's really outside their character, talking about what they're like. But not in this case. Anyway, we have to go back to court. Let's see. There's a new witness on the stand. Let's see what we got here. Okay, so far we've heard from a 19-year-old girl who's seen Oliver around in her community. We've heard from a former neighbor, and now his landlord, the manager of his building, who said he paid his rent on time. And guess what? Never any complaints. I'm still pretty floored by the defense strategy here. Michael, let's talk about this for a minute, because I don't really think this guy's doing himself any favors. These are just, these witnesses are making my jaw drop, because, first of all, they don't know anything about his history. They don't know anything about him on the job. What do you make of all this?
I think that the jury is going to see through this. They're just throwing things against the wall. If you want this jury to show some compassion to Oliver for his actions, they should get rid of all these witnesses, put Oliver on the stand, have Oliver accept responsibility for his actions, apologize to this family, and move forward. They're taking a big risk if they're playing for some appeal or anything of that nature with this case, because this jury's got their fate in their hand, and they want to hear that this man takes responsibility and is sorry for the tragedy that was caused to the family of that young man. Not his tragedy, the family of that young man who won't get to see their baby anymore.
Absolutely. Well said, Michael. I completely agree with you. It's a little bit shocking, the strategy here. We do have to go to a break, but then we will be back live in the Oliver courtroom. So that was Officer David Fields, the defendant's former partner, and the first witness who really did possibly accomplish something for the defense, although the cross-examination was pretty strong, don't you think, Michael? Specifically identifying some of the issues that have been flagged for the jury. And in that case, the witness didn't know anything about it.
I think this was the first credible witness who lent some sort of knowledge to the jury that they've called, but he was very forthright. The one thing I don't understand about the defense's strategy here is they seem at times to be retrying the case. And I don't think that's effective to do in a jury that just convicted. You're almost arguing with the jury. What you're trying to do is give them insight. I think the one nugget that the defense got out of this witness was that a shooting by an officer has a lifelong effect on the person. However, the only problem is this officer wasn't swearing at the jury. He was very respectful. He was very honest. and he said he didn't know what he didn't know. He didn't try to make up excuses for Oliver. He just said, as I know him, this is how he's acted. I think the prosecution did a great job saying you don't know him that well and you haven't ever been with him in these situations that the jury found he's been in. That's where I think it was. But it was much better and a much more professional presentation than the first three witnesses.
Yeah, a little bit more effective. This is someone who knows him in the capacity of his job. Of course, like you said, the fact that he had yelled at a jury, anger management, that had held a gun to someone's head, what was it, 2 months before? I mean, all of that, he didn't know. He said he was surprised. I thought the prosecution did a good job with this Jekyll and Hyde analogy, kind of undercutting some of the prior testimony. Like, you might be a great guy in your apartment complex. You might even be a great guy in the police vehicle when we're riding around as partners, but you're not always such a great guy.
And I thought that was very effective. And I think that the analogy of Dr. Jekyll and Mr. Hyde will impress a jury because that's something now that's going to stay with them. And I don't really know of anybody who can't identify with that character, because we've all grown up with the book is a classic. And I think that was good on a lot of levels on the prosecution. I thought that was very effective in a very small amount of time with a very small amount of questions.
Yeah, and you're right. And the prosecution had a lot to work with, especially with when it comes to those first three witnesses. This officer presented very well, as you said, super honest, not trying to say something that he doesn't know, not trying to stretch. But those first three witnesses, they don't know Oliver in his capacity as a police officer. They didn't know too much about him. This Facebook post, to me, if I'm a juror, that's going to stick with me.
And it was effective that the officer who just testified lent him a lot of credibility by the fact that he said, I do find that offensive, in words to that effect. But it was also effective, the emotion he showed, because he himself was involved in a shooting. But then again, he himself was not indicted, charged, and convicted.
Right, right. And that's what we needed to make sure that everybody understands. He's convicted. This is the penalty phase. So we will be back in the courtroom live. There's a recess. Stick with us. We're going to a break. Right, looks like the prosecution has rested in the Kilgore case. So we will see what happens. They're taking a break right now. When we come back from the courtroom, we'll see where the defense is going to go. But let's talk about this case, Michael. So Kilgore, the prosecution just rested. We did see some forensic evidence being put on the stand. We know that there was testimony regarding the arson, that accelerant was used. We do know that a lot of evidence can be lost in these types of cases, though, correct? When you have a fire, the purpose of which is to destroy evidence, but it can do that as well.
Absolutely. It causes a problem for the prosecution because of the destruction of evidence, and that's why they have that charge of destruction of evidence. But the problem is the arson investigations and the forensics of that have become so more fine-tuned than they were years ago. I mean, once you find an accelerant, the circumstances around it, regardless of what the evidence is destroyed, is going to cause a major problem for the defense, especially in this case because of the circumstances.
Yeah.
There's that. I really think one of the key witnesses is the witness who saw her leave, was one of the last people she saw with the gloves on, and she said she had poison ivy, and she told the nurse that, who thought that was unusual. And the fact you have that receipt, that's really going to bolster all the other evidence.
Yeah, certainly that is unusual. And the defense saying it wasn't her. When she left, pawn shop owner was fine. There is some activity in court, so we're going to go live to the courtroom now, see what's going on. They're talking about jury instructions in the Kilgore court. This is the judge. We're going to come out of this case now while we wait for the defense to put on their case. Will the defendant testify as promised in the defense opening statement? All right, Michael, let's talk about this. The prosecution's case is done. They had forensics, they had circumstantial evidence, they had witnesses, and now time for the defense. We don't know what else is to come, but we know a promise was made. Well, what do you think?
You've got to put your money where your mouth is in these situations because you did make that promise to the jury. And if you don't put forth your defendant now after promising the jury's clearly going to think you're hiding something because you've brought that up. Technically, under the law, they're not allowed to because what we as attorneys say in our openings is not evidence. And you still have the constitutional right, and the jury can't draw any inference from you not testifying. However, there's also another thing that you really, as a trial lawyer and as a person who tries a lot of cases, you realize sometimes it just ain't going to get any worse.
Oh, yeah.
So if you're in a problem where the witness, where it's overwhelming, and if you go by the way you're supposed to go, the jury is going to convict, then you see if maybe your witness, it's the Hail Mary pass in some instances. And I fault no lawyer for doing that, because that's what sometimes you need to do, because that's the only shot you have.
Yeah, look, Michael, sometimes you have to, right? And that might be the case here, that the defendant's side of the story, she's the only one who's going to be able to tell it, who's going to be able to say she left, and that pawn shop owner, the victim in this case, was still alive. So only time will tell, but I agree with you, Michael. You cannot unring the bell. You promised that testimony in the opening. Even though legally it's not required, the jury is going to be scratching their heads if you don't have the defendant on the stand. We're going to go to the testimony of Mark Wilson to review some of the clips from the trial a little bit earlier. He is the TBI assistant detective. So let's go to his testimony now. We're watching prior testimony from the Kilgore trial. We're speeding through here with the prosecution resting today. That was Mark Wilson showing us some photos. Michael, let's talk about what we found in the defendant's car. Bag of guns, knives, and accelerant. Funny enough, that's what was used in the arson, according to experts, the forensic experts in this case. What do we think of this?
Well, it's very dangerous for the defense, because now we have lighter fluid. That's an accelerant. And I don't recall seeing any cigarettes or a lighter that could use lighter fluid. It's just amazing to me that this defendant committed such a heinous crime as she's accused of, and had some window of opportunity to rid herself of the evidence that's found in her truck. It looks like she's writing another bank loan like she did during the last robbery.
You're right. Well, we'll probably hear about that during her testimony. Explain some of that away, if possible. We do have to go to a break, but stick with us. We just watched Officer Raymond Keener, a friend of the defendant, talking about Roy Oliver and how he is someone that he trusts, has his back. Again, the defense cross-examines with those points that we've heard hammered home time and time again. Michael, it seems like that's what the prosecution is really focused on, right? Those points of the Facebook post, obviously, his prior disciplinary issues, the fact that he was in anger management. That's really what the defense harps on. I think they could have taken this guy to task a little bit more, to tell you the truth.
I think they could have, and I think they didn't, because I think they felt they made the points they needed to make. One of the things that really got me about this witness, who's supposedly his friend and a police officer, were two things he said that I think were harmful. Was the fact he's his friend, yet he wasn't aware of the Facebook post about the one thing I do is kill people. So it doesn't seem like, if all these guys are using Facebook, that they're keeping in contact. The other thing was, and I thought the prosecution could have hammered a little more on the fact that he said it's important that a police officer know the other officer has his back when he goes into the community. We're not talking about a police officer shooting another police officer. It appears what would be paramount and should be paramount is that when a police officer goes in the street, the community feels he has their back.
Right.
And
absolutely.
That is something I think that they could have harped upon with a little more emphasis. But otherwise, this witness, I think, was pretty non-consequential.
Yeah, I do think they could have made the point that, hey, you want to make sure someone has your back. Well, would you say anything here today? Anyway, we'll see what happens in the courtroom. Stick with us. We have to go to a break, but we'll be back. Another neighbor on the stand for the defendant, Teresa Vance, former neighbor, talking about, sounds like a situation that the defendant diffused in a peaceful way. Michael, what do you make of this? I mean, I'm not sure that we're really getting past the issue here. I think the two former officers were probably the most credible witnesses. The people from this apartment complex are not really doing it for me. What do you think?
I don't mean to say this disrespectfully, but you got to call things the way they are. It's almost like a joke. It's like a bad reality show here. This has nothing to do with Oliver and his mitigation. These are people who really don't know him well. I think the prosecution's brought that out. He comes and goes. They haven't been on the street with him. The jury's heard all the bad things about him, and there's really nobody here who's come forth and said, like, Oliver did anything to change their life other than, do what he, a couple people who are emotionally disturbed. It's just, it's very
and
confusing.
Being a good neighbor and loving his own child. I mean, that's really been the theme, and liking the other kids in the complex. The apartment complex scenario is really not serving as, let's look at this from a macro perspective. We're supposed to be looking at mitigating factors, things that will make the jury say, let's not put this guy away for 99 years.
And I think the only person who could say anything to save the day now is Oliver. And this other is going to start wearing on the jury's nerves because the prosecution keeps making sure they hear about their 4 most important issues, and they hear about it after every witness.
Yeah, and Officer Keener saying he's, Oliver's taking his punishment. Oh, look, he's taking it like a man. But yet he's on trial, so yeah, he didn't run away. Anyway, we have to go to a break. I'm out. Bob the Yankee, my friend, is in. Stay with us.